Late this afternoon, I want to share news of a legal earthquake, one that arrived quietly in a federal courthouse filing and was largely drowned out by louder stories about congressional investigations and campaign rallies. Still, it shouldn't be dismissed. What took place in a Washington, D.C. federal courtroom at precisely 3:47 p.m. Eastern marks the first time in American legal history that a former president has been declared an active flight risk by a federal judge. Judge Tanya Chutkan, overseeing the federal election interference case, issued an emergency order freezing Donald Trump's passport, exposing him to what legal experts describe as the most severe pretrial restrictions ever imposed on a former commander-in-chief. At a glance, this could be mistaken for routine judicial housekeeping, another procedural motion in a mountain of legal paperwork. But this was never about travel logistics or passport administration. It's about whether a former president facing 91 criminal charges across 4 separate indictments will be treated like any other defendant accused of attempting to overthrow American democracy. At a glance, this could be mistaken for a mundane administrative dispute, another squabble about travel documents and court calendars. But this was never about whether Donald Trump can vacation at his golf resort in Scotland or attend a ribbon-cutting ceremony at Trump Tower, Dubai. It's about accountability, the principle that no individual stands above the law, regardless of wealth, political power, or past office. What follows will uncover the parts of this episode most people haven't seen, why federal prosecutors became so intent on restricting Trump's movement, why Judge Chutkan responded with such unprecedented severity, and why the Justice Department, an institution that has frequently moved with caution in cases involving powerful political figures, finally decided this was the line that could not be crossed. To understand how we arrived at this moment, the sequence of events matters. Roughly 6 weeks ago, federal prosecutors filed what appeared to be a routine motion requesting standard pretrial conditions for the defendant. Buried within the 37-page filing, however, was a detailed analysis of Trump's international business entanglements, his access to private aircraft, and what prosecutors characterized as credible intelligence suggesting discussions about potential relocation. What followed went far beyond typical pretrial restriction requests. The objective was to establish a legal framework treating Trump as what court documents explicitly state, a defendant with means, motive, and demonstrated willingness to evade judicial authority. At exactly 3:47 p.m. Eastern on Tuesday afternoon, Judge Chutkan's chambers released a 9-page emergency order that sent shockwaves through the American legal system. The ruling didn't simply recommend passport surrender. It demanded immediate confiscation, ordered the State Department to revoke Trump's diplomatic passport, and established 24-hour electronic monitoring requirements. Federal prosecutors had presented evidence that legal observers describe as both damning and unprecedented. Court filings obtained by investigative journalists reveal that Trump's legal team had quietly inquired about extradition treaties with at least 7 countries, including the United Arab Emirates, Saudi Arabia, and Hungary. These weren't casual inquiries about vacation destinations. According to sources familiar with the court proceedings, Trump's attorneys specifically asked about nations without extradition agreements with the United States, jurisdictions where American legal authority effectively ends at their borders. The court document includes a disturbing detail that prosecutors emphasized in closed-door proceedings. Financial disclosure forms analyzed by federal investigators show approximately $487 million in outstanding loans to foreign entities, with $340 million in debt payments coming due within the next 18 months. Legal experts who closely track Trump's behavior note that a defendant facing potential decades in federal prison, combined with crushing financial obligations to foreign creditors, creates what the Justice Department characterizes as extraordinary flight risk. Court insiders noticed unusual activity within Trump's inner circle, encrypted communications with foreign business partners that had not taken place in more than 6 months, sudden asset transfers to offshore accounts, and what witnesses describe as increasingly desperate conversations about legal strategies if extradition became necessary. The timeline reconstruction reveals a pattern prosecutors argue demonstrates consciousness of guilt and flight preparation. On August 3rd, Trump's personal attorney contacted a Dubai-based law firm specializing in international residency applications. On August 11th, financial records show a $12 million wire transfer from a Trump Organization subsidiary to a shell company registered in the Cayman Islands. On August 19th, flight logs confirmed Trump's private Boeing 757 underwent maintenance specifically configured for extended international travel, including upgraded fuel capacity allowing non-stop flights exceeding 7,000 miles. Judge Chutkan's ruling emphasized that preliminary evidence suggested Trump had begun positioning assets and establishing contingency plans before any formal court order could prevent such actions. The court determined that these financial maneuvers constituted a direct violation of pretrial release conditions and, more fundamentally, breached the sacred compact between defendant and court. This financial architecture explains today's emergency intervention. Federal prosecutors identified what they describe as a systematic effort to create escape infrastructure, a deliberate construction of legal and financial mechanisms designed to place Trump beyond the reach of American justice. The judge's language was unequivocal. The ruling emphasized that pretrial release is a privilege, not a constitutional right, and that privilege depends entirely on a defendant's demonstrated willingness to submit to judicial authority. The passport freeze is more than an administrative inconvenience. It is a legal declaration, a formal judicial finding that Donald Trump poses a credible, immediate threat to flee American jurisdiction rather than face accountability for alleged crimes against the democratic process. It represents the clearest statement yet from a federal court that a former president will be treated exactly like any other criminal defendant, subject to identical restrictions, identical monitoring, identical consequences for attempting to evade justice. Which brings us to the Justice Department itself. For much of the past 3 years, federal prosecutors moved with extreme caution in cases involving Trump, consistently applying what legal observers describe as a double standard favoring powerful political figures. So what shifted? Why did the DOJ at this particular moment choose to pursue the most aggressive pretrial restrictions available under federal law? It had nothing to do with a newfound passion for equal justice. The real reason is vulnerability and calculation. In Washington, prosecutorial authority rests as much on perception as on legal precedent. When credible intelligence emerged suggesting Trump was actively preparing escape contingencies, it sent an unmistakable message to DOJ leadership. Failure to act would permanently damage institutional credibility. This episode marks one of the clearest signs yet that Trump's grip on institutional protection is weakening. For years, political calculations shielded him from consequences that would have destroyed any other defendant. Today's ruling represents the first real indication that courts are willing to treat him as what he legally is, a criminal defendant facing overwhelming evidence of serious crimes. Federal prosecutors describe the passport freeze as necessary, proportionate, and fully consistent with how flight risk is assessed for any defendant with comparable resources and comparable charges. Legal experts note that no former president has ever faced such restrictions because no former president has ever been indicted on charges of attempting to overthrow the constitutional order. The precedent being set will shape how courts handle powerful political defendants for generations. Still, it would be reckless to underestimate the broader implications and the institutional battles this ruling represents. The cultural consequences are equally significant. Trump and his legal team understand a simple but powerful truth. American democracy depends on voluntary compliance with judicial authority. Controlling the narrative around court legitimacy is a direct route to controlling whether supporters view legal proceedings as justice or persecution. His goal has always been to overwrite the legacy of judicial independence, one built on impartiality, evidence-based rulings, and equal application of law, with a narrative rooted in political conspiracy, deep state persecution, and victimhood mythology. The court may have stopped Trump's physical movement, but it cannot end the larger struggle for the soul of American legal institutions. That battle is playing out in courtrooms across Georgia, where Trump allies face identical RICO charges, in New York, where financial fraud proceedings continue despite relentless attacks on judges and prosecutors, and in Florida, where classified documents cases proceed against a defendant who has publicly declared intentions to defy unfavorable rulings. The passport freeze was merely the most visible tip of the iceberg, a symbolic flashpoint in a systematic effort to determine whether American courts retain authority over politically powerful defendants or whether wealth and political influence create immunity from legal accountability. This is not about one passport or one defendant's travel restrictions. This is about whether the rule of law applies equally to all citizens or whether a former president can position himself beyond its reach. And let this serve as a clear message to those in power. We are watching the court filings. We are watching the financial transfers. We are watching every attempt to construct escape mechanisms. We will not allow constitutional principles to be liquidated piece by piece, traded away for political expediency or fear of powerful defendants. Still, it would be reckless to underestimate the danger ahead. A defendant who feels cornered, stripped of escape options, and facing the genuine prospect of federal incarceration is not a diminished threat. Trump has never accepted judicial authority quietly. He doesn't interpret court orders as lawful checks on behavior. He interprets them as declarations of war, personal attacks demanding retaliation. The next 72 hours matter critically. With international travel now off the table and $487 million in financial obligations looming, his legal and financial vulnerabilities have only intensified. Pressure shapes behavior, and when legitimate escape routes are eliminated and conventional legal defenses collapse, attention inevitably shifts toward more dangerous alternatives, which brings us back to the warning about defiance of court authority. As legal options narrow, expect a sharper turn toward direct confrontation with judicial institutions themselves. Watch for public statements explicitly rejecting Judge Chutkan's authority, designed to prime supporters for potential refusal to comply with future court orders. Expect emergency appeals challenging not just this specific ruling, but the legitimacy of the entire prosecution. Anticipate increasingly desperate legal theories claiming presidential immunity extends indefinitely, creating a constitutional crisis if courts reject such claims and Trump simply refuses compliance. Desperation doesn't retreat, it adapts. We may also witness attempts to flee despite court orders, violations of electronic monitoring requirements, or coordination with foreign governments willing to provide sanctuary in exchange for future political favors. Today's passport freeze represents a clear win for judicial authority, but it also raises the stakes dramatically. It increases the temptation to pursue options that would once have seemed unthinkable. To the citizens who have felt powerless watching institutions bend and break under political pressure, I want to speak directly. I know how easy it is to feel like the courts designed to protect us are compromised. I know the disillusionment of seeing civil legal norms disregarded, judicial orders ignored, and accountability delayed year after year. But look at what occurred today. Look at the scoreboard. A federal judge declared a former president a flight risk and stripped his passport. The Justice Department presented detailed evidence of escape preparation. Yes, appeals will follow and legal battles will continue, but the institution still functions. That should remind us that if one judge can stand firm against political pressure, so too can the entire judicial system itself. We cannot safeguard one courtroom's integrity while ignoring broader attacks on legal institutions. Across every jurisdiction, facts must guide us. Every citizen deserves transparency and accountability. Those prosecutors who pursued this motion with courage must show identical resolve across all cases, regardless of defendant wealth or political power. And let this serve as a clear message to those in power. We are watching every court filing, every motion, every attempt to delay or evade justice. Democracy is not a spectator sport. It requires active participation, constant vigilance, and courage from every one of us. If this breakdown helped cut through the noise and explain what's truly at stake, consider subscribing. Sustaining reporting that prioritizes context over outrage is essential during moments like this. I'd like to hear how you see it. Do you believe Trump will comply with this order, or are we witnessing the beginning of direct defiance of judicial authority? Let me know in the comments below. Thank you for watching. This story is far from over.